Minutes. Great, we'll call the group file for the bail hearing for KODA JIMENEZ 26 GF 37016 appearances.
John Vick for the state. Mr. Jimenez appears in person with Attorney Gibson Hatch.
All right, and counsel, do we have a good address for your client?
Sam. 752 Logan Street, Janesville.
Yeah, that was at 53545. Okay, so this was scheduled for an initial appearance. I don't have a criminal complaint. What does the state know about that?
Unfortunately, Commissioner, I don't have a ETA on the complaint. I do have a bail recommendation, however.
Okay, and how far out are you asking that we go for an initial appearance?
I don't have any notes. I suppose an out of custody IA in maybe a month would be fine.
Okay, and what is your position on bail?
The state would request a signature bond with conditions that the defendant have no contact with Addison W. ADDISYN, that he be banned from the 48 Goldenrod Lane here in Madison, and that he be banned from the 3000 block of Midvale Drive in Janesville.
Great, any objections?
Or we would join in the request for a signature bond. We'd have no objection to the bond condition preventing contact with Addison W. Regarding the two addresses that were listed, unfortunately, I was just handed the probable cause statement shortly before this hearing. Asked the state to confirm that those two addresses are specifically associated with Addison W. Prior to agreeing to any sort of no
Well, the
contacts.
Goldenrod Lane appears to be, looking at the PC affidavit. Attorney Bake, any response to the other address ban?
Just one moment while I review the files here.
And while he's taking a look at that, does your client have any reason to be on the 3000 block of Midvale?
No, at this point, Mr. Jimenez did inform me that it is associated with Addison W. We would not object to that either.
Okay, I'll order a signature bond. Condition will be a no contact direct or indirect with Addison W. A ban from the 3000 block of Midvale, and you said that was in Janesville?
Yes.
And a ban from 48 Goldenrod Lane. We'll find a date for out of custody initial appearance about a month out.
Right now, I'm looking at March 30th, 8:30, it's Monday morning.
You said 8:30?
Yes.
Yeah, unfortunately won't be available.
Next Monday, April 6th. 8:30.
Someone from my office should be available.
All right, so Mr. Jimenez, it's going to be real important that you follow the bond conditions here. You were charged or arrested for stalking. You haven't been charged yet, but that means you're subject to felony bail. You violate any of these conditions or picking up new cases, you can be charged with felony bail jumps. So make sure you abide by these conditions. We'll be adjourned for today.
Thank you.
All right, 2 minutes, right this way. Next up is Shantay Tyler. No.
Sorry, my computer froze. Can we just wait a minute? Work on case.
Yeah, the wireless internet doesn't seem to be working. Great.
Why?
On.
This doesn't go into Ethernet, does it?
I don't believe so, but it's worth a shot.
Yeah. This might be a pain.
Tyler? Okay. Back.
Yeah, we got a full calendar.
I should.
This, yeah.
You take that with you after we're done here. Did you get?
Can we do? Case? Yeah, sure. Can we do one first after this, yeah.
It seems to be working for now, so go for it.
Okay, you're all set? All right, we'll call the state of Wisconsin versus Shantae Tyler. It's 26 CF 501 appearances.
John Vick for the state.
Shantae Tyler appears in custody in person with Attorney Annika Vermaak.
And do you have a copy of the complaint?
I do have a copy of the complaint. I was able to go over it with Ms. Tyler earlier today. We would waive its formal reading.
Do we have a good address for your clients?
The AYOUB. .303 Latham. Is that right? Yeah. Room 213. Madison, Wisconsin, 53726.
Great, I'll make findings of probable cause. There's a public safety assessment. If you don't have a copy of that, Attorney Ventola probably has that in his paperwork.
I do have a copy.
Recommends a signature bond, state's position on bail.
State also recommends a signature bond with conditions that the defendant not possess or consume any alcohol and that she have no contact with Officer Riley Patton unless in his official capacity.
Spelling on that.
It's just like the general, Patton.
Any objections?
No objection.
All right, order signature bond condition will be that you not possess or consume any alcohol at all. You have no contact, direct or indirect, with Officer Riley Patton except as necessary in their duties as a law enforcement officer. As to time limits,
I would like to schedule within time limits, please.
okay, we'll get that set and the clerk will let you know what we've got for a freedom date.
Right now I'm looking at March 19th at 8:30.
Did you say at 8:30?
Yes.
I can make that work. Thank you.
Okay, we are adjourned.
This way. Okay, this Jose Trinidad. Trinidad.
Long time no see.
Was that Sunday?
We'll call the state of Wisconsin versus Jose Trinidad. It's case 26 CF 512 appearances.
John Vick for the state.
Jose Trinidad appears in person and represented by Doug Phoebus of Ariano and Phoebus.
All right, and do you have a copy of the criminal complaint?
I do have a copy of the criminal complaint, will waive reading. And I guess we've got one misdemeanor, so we'll enter not guilty on that.
And do we know if the Fremont Avenue address is correct?
It is.
All right, and let me swear in the interpreter. We have certified Spanish interpreter Fred Svensson. Mr. Svensson, if you raise your right hand, I'll give you the oath. Do you swear or affirm that you will truly, accurately, completely, and impartially interpret the proceedings? I'll make a finding of probable cause, enter a not guilty plea, state's position on bail.
State's recommending a signature bond. Conditions that the defendant not operate a motor vehicle. That he not possess or consume any alcohol. And that pretrial services be employed to monitor alcohol levels.
Right, any objections?
Judge, my understanding is there's a hold from immigration. Given that, I'd prefer $100 cash bond so that we can try to get him bail on the immigration before he gets released from Dane County.
All right, well, I'm not gonna set a token bail. Mr.
Actually clarify, it's not an immigration role, it's a request for advance notification of release.
But I'm not gonna set a token amount of bail. If there's a basis for cash bail, I'll hear the arguments and set an appropriate bail.
Let me ask this, if we do a signature bond, can he hold off on signing that?
You'd have to ask the jail as to whether they'd release him. I don't know what their procedures are as far as if somebody doesn't sign, whether they won't release them.
How much cash bond did you have in mind? $200?
Well, I don't know that I've got cash bail in mind because the state suggested a signature bond was appropriate. But I'll take a closer look at his history and
I would say the last prior offense was 20 years earlier. He's married. He's been in Madison for 23 years. In this case, he was found sleeping in a parking lot, so there was nobody who was injured.
well, I guess I'm not hearing a great argument for cash bail. I'm not gonna set a minute amount of bail that gets held against the court for setting low amounts of bail that potentially keep people incarcerated. So I'll order the signature bond. I will order that you report to pretrial services no later than 10 a.m. on the business day following your release from custody. I believe the interpreter's giving you the map there on the 5th floor of the Dane County Courthouse. I'll order that you be equipped with a breathalyzer, that you not possess or consume any alcohol, and that you not operate a motor vehicle at all. You would have the right to a preliminary hearing in 20 days. Your position on that?
Oh, we'll waive that time.
Okay, I think the clerk will let you know what we've got for a status date if you want to hang on.
All right.
Right now, I'm looking at April 20th at 3:00. Of course, this is just a status regarding the prelims. If you want to waive the prelims, you can send us a letter. If you want to have a prelim, you can send us a letter.
April 20th at what time? That one doesn't work. In trial. I'm in trial here in Dane County.
We have April 27th, 2:00. Like I said, it's just a
Yeah,
status
that's fine.
regarding the prelim. So if you want a prelim, you can send a letter. If you don't want a prelim, you can send a letter. Like I said earlier, look at the documents.
Yeah, well, April 27th is fine.
Okay, we are adjourned if there's nothing else.
Maggie? Next up is AYOUB HRYZY appearing by Zoom for bail bond hearing. Thanks, Fred.
Long time no see.
We'll go on the record in the state of Wisconsin versus AYOUB HRYZY. It's 25 CM 2383 and 25 CM 2442 appearances.
John Bake for the state.
AYOUB HRYZY appears in custody and via Zoom by attorney Haley Watson. I appear physically in the courtroom. He appears in a separate location via video.
All right. All right, now I see Mr. HRYZY. Looks like we're here for return on warrant. There was a failure to appear on December 18th of last year. Any info you want to provide about that, Attorney Watts?
I would just note that the gravity of the offenses here is quite low. We've got 2 misdemeanor cases. 2 of the 3 underlying charges are simple disorderly conducts, though with the repeater enhancer. I would also like to raise the issue of competency based on my conversations with Mr. HRYZY. I have reasons to doubt that he's able to understand the proceedings and to assist in his own defense. And so I'm asking that a competency evaluation be conducted and also asking that the court impose signature bonds here.
Okay, and state's position?
The state would request just a modest amount of cash. Defendant failed to appear in mid-December last year. He's been in warrant status for about 2.5 months. He also does have one other failure to appear in February of 2022, which was served in March that same year.
All right, Looks like there was a public safety assessment done at one point that recommended modest cash bail. Had him at the time a 5 out of 6 on new criminal activity, a 4 out of 6 on failure to appear. That was before the latest failure to appear. Attorney Watson, anything else?
Judge, I just ask that you consider the competency I'm raising and imposing bail here.
All right, well, I'm directed by local court rule to address bail even when competency is raised. I think given that he's been out on the warrants for a couple of months as a prior failure to appear, had a PSA report that suggested there was a need for cash bail, which is borne out to be true. Some cash bails warranted here, given the nature of the charges being misdemeanors. I'll set $150 cash bail and 25 CM 2442. And I'll set $300 cash bail and 25 CM 2383. The prior non-monetary conditions will remain. And I'll find a basis to doubt competency based upon Attorney Watson's representations and order a competency evaluation and suspend the proceedings. We at one point had a phone number at 608-422-9273. Do you know if that's still a good phone number?
If I receive information that it's not, I'll let the court know.
Okay, well, we just had an issue with the competency evaluators saying that they're having issues contacting people. So it's very important that we get that. I'm not sure, Mr. ALRYZY looks like he's walked away from the window. If he could, is there a good phone number for you, sir? Is the 608-422-9273 still a good phone number? I didn't hear any response. Do you know, is the Rethke Avenue is still a good mailing address?
As far as I know, but again, I'll update the court as needed.
All right, appreciate that. We'll be adjourned.
And this will be scheduled back in courtroom 1 AM Monday afternoon, since competency was raised during a commissioner bail hearing. We'll not go back.
Understood.
Great, we are adjourned.
Next up is Mason Gunderson.
Great, so we'll go on the record in the state of Wisconsin versus Mason Gunderson. It's 26 CF 517. There's also a bail bond hearing on a pretrial services violation in 26 CF 11. Could I get the appearances?
John Bake for the state. Attorney Jeremy Evans appears as a friend of the court for CF 26 CF 11 and on behalf of I'm sorry, the other way around, my apologies. Appears as friend of the court for 26 CF 517 and on behalf, I'm covering for Attorney Eric Habich, who represents him on 26 CF 11.
Okay, and I guess that leads me to believe that maybe Mr. Gunderson needs to do something to hire Attorney Habich on the new case or retain your firm or whatever. If you're not able to do that, you can always apply for a public defender. The deputy's giving you that information. If you find yourself caught in the middle, you can apply for a county appointed attorney. You've got the new complaint, the 26 CF 517.
Yes, Your Honor, I acknowledge receipt of the complaint. I waive its reading. The address is current.
Right, I'll make findings of probable cause for the charges, enter not guilty pleas to the misdemeanors. And then there was a pretrial services violation. I don't know if you've got a copy of that report, Attorney Evans.
I do.
All right, and let me just take a look at that. Yeah, so it looks like the violation was the new arrest, state's position on bail.
I'll start with 26 CF 517. State is requesting $25,000 cash bail with conditions that the defendant not operate a motor vehicle, that he not possess or consume any alcohol, and that he be banned from Club Bristol. As for 26 CF 11, I'd ask that bail be forfeit and an additional $15,000 cash bail along with the previously and stated non-monetary conditions.
Here, the defendant's on a $15,000 cash bail in that 26 CF 11 case. It's alleged that he goes to Club Bristol, that he's drinking there, that he stays for a few hours and then exposes himself to a dancer. He's forcibly removed from the club. There is a witness who observes him leaving, driving in his Jeep. His driving's not great. He crosses the center line. He hits another vehicle. Thankfully, the passengers of the other vehicle are not injured to my knowledge, but he leaves the scene and decides to then walk to a bar and order a drink and play slots. So law enforcement enters the bar. He's not truthful about his name. He's confronted. He admits to driving the Jeep. But then starts saying that the other vehicle, he blames the other vehicle, saying they crossed the center line. There are obvious signs of impairment. He refuses field sobriety and as well as a preliminary breath test. Given the blatant disregard for his bond conditions, lying to law enforcement, he's also resistive at the hospital to the point where they have to call security staff and deploy tasers. And given the fact that he was already on such high cash bond, clearly a significant amount of cash bail is necessary. Thank you.
Great, and the defense position?
The defense position, 26 CF 11. We would ask that that bond not be forfeited. And that an additional, a modest additional cash bail for that of $1,000. As for the present case, the most recent, we would ask for a lower cash bail, $1,000 or $2,000, and that the court consider electronic monitoring and alcohol monitoring, given that these incidences are involve alcohol. I think that making sure that he is alcohol-free will probably ensure his bond compliance moving forward. He does care for a child of his partner's. He's in the middle of closing a business. He has therapy and a therapist appointment and psychiatrist. He's under the care of both a therapist and a psychiatrist. He has major depression and anxiety. So that's what we would ask of the court.
Great, and any response?
No, the state rests on its previous argument.
All right, well, it's quite concerning that we're back here. I think this is now the third case that's open. He had a significant cash bail, had the pretrial services. There's not a lot more that I can do other than increase the cash bail. The statutes say that the cash bail can be forfeited for violating conditions of bail, picking up new cases, missing court. In fact, they say shall forfeit with the ability to have that overturned if it's not in the interest of justice. I don't believe Mr. Gunderson specifically posted that bail, as I understand the bail sheet. I think that's something relevant to take into account here today. But I don't see the ultimate result as simply modest cash bail. Because quite frankly, if I forfeited the $15,000, you would have that lost, or whoever posted that for you. And there'd still be a good argument for a bail higher than $15,000 in that particular case. So I'm not going to forfeit it because I think somebody else posted that. If they're watching, they should be on notice. If we're back here for future violations, I don't think we've got much choice other than to forfeit that bail. And these are significant sums, I assume, to that other person. I'm going to set $30,000 cash bail and 26 CF 11. That takes into account I'm not forfeiting the $15,000. I'll order pretrial services with the prior conditions. In 26 CF 517, I think $5,000 is sufficient. I will order pretrial services there. I do think that there needs to be monitoring for alcohol use. So you'll be equipped with a breathalyzer this time in addition to the GPS that you had previously. I'm going to order that you not operate a motor vehicle, that you be banned from Club Bristol, I'll also order the GPS in that new case to monitor the address ban. And you're obviously familiar with their offices. They've given you the map again. You got to be there no later than 10 a.m. in the business day following your release from custody. As to time limits for the preliminary hearing.
We would like to, I just wanted to clarify for CF11, a total of 30,000, including the 15.
Total of 30,000. He has 15,000 that applies because I declined to forfeit that.
Okay, so another 15. Okay.
That's why I said it as high as I did, because I wasn't forfeiting the bail.
We would like to have the preliminary hearing within the time limits.
Okay, if you've got a calendar or Attorney Havish's calendar, the clerk will let you know what we've got available for date and time.
We're now looking at March 10th, 3 o'clock.
I'm afraid he is not available then.
At the 11th at 1:30.
That's cutting it close. He has to be in Columbia County in the afternoon. Actually, that might work. You said 1:30?
Yes.
Okay.
Right, we should go with that date then.
Yes, that'll work.
Okay, we are adjourned. Thank you.
Next up is Samuel Germany. Hearing by Zoom.
All right, we'll go on the record in the state of Wisconsin versus Samuel Germany. That's 25 CM 1572 and 26 CM 55 appearances.
John Bake for the state.
Good afternoon, Your Honor. Charles Verhoeven appearing on behalf of Samuel W. Germany, who's appearing by Zoom conference.
All right, I think we had an address of the Beacon. Is that still the correct place for him to get mail?
You can use
I think
for
we
that.
have the trail on another one.
Because the trail.
All right, we'll use the 4006 Nakusa Trail as an address in both files.
That's correct, Your Honor. That's a safe haven.
All right, looks like there was a failure to appear on February 26th of this year. Any information you want to provide about that, Attorney Verhoeven?
Your Honor, prior to the hearing, I called over to the people at Safe Haven and they said that Mr. Germany had gotten on the bus and was on his way to court. He didn't make it to court, obviously. This was on February 26th. The warrant was served on him on the 28th, return on warrant on the 2nd. I believe he got served with and placed in custody on the 28th. So this is not a very short period of time that he's been where that warrant was outstanding. He does have a prior where this happened on December 12th of 2025. And he did appear on that on January 16th, Your Honor. I've received an offer from the state in regards to a resolution of these three cases. There's a case that involves, these are not violent offenses. The one case involves possession of controlled substance. I think Mr. Germany is eligible for the drug court treatment program. And that would be an appropriate resolution, Your Honor. He is not able to pay a cash bail due to his indigency. And I would ask that the court reinstate a signature bond.
All right, thank you. And state's position on bail?
State would ask for moderate cash on both cases. He does have quite extensive warrant history. Of course, he failed to appear earlier last month. as mentioned by Attorney Verhoeven, also happened in December. But also, I'm seeing warrants from 2024. I think one in 2024 from Dane County. I believe there are 3 in 2022, one in Dane County, and the others in Jefferson. I'm sorry, there are 2 in 2022, and then another one in 2021. Given the amount of warrants, I would ask for moderate cash.
Any response to your home?
Your Honor, I think that Mr. Germany would be able to appear at all future court hearings, and that these matters will be resolved in a very near future if the court will allow him to be released on a signature bond at this time.
All right. Well, for his first failure to appear, it'd be a different story. It's not, he's failed to appear twice in roughly 3 months, has several other failures to appear. Notably, the initial appearance in 26 CM 55, he was a 5 out of 6 on the failure to appear, 6 out of 6 on new criminal activity, and it noted failures to appear of 1 in the last 2 years, failures to appear older than 2 years. He certainly knew about the court date. He apparently left Safe Haven and got on the bus and didn't get here. Doesn't appear that he jail. I don't have any choice but to set cash bail. I'll set $300 cash bail in each case with the prior non-monetary conditions. It'll go back to the branch, and certainly if there's an agreement that the matter be resolved, then it can be done at that point in time, or you can file a motion to review the bail. We'll be adjourned.
Thank you, Your Honor.
You're welcome.
Next up is Davion Washington.
All the rest of the afternoon. Can't imagine a better way to spend my Tuesday. We'll have fun.
Call the state of Wisconsin versus Davion Washington. It's 26 CM 502 appearances.
John Bake for the state.
Mr. Davion Washington appears in person and in custody alongside Attorney C. Joseph Antola. We have received a copy of the criminal complaint. I can confirm that the address on it is correct. We would waive its formal reading, stand mute as to the single misdemeanor charge, and at this time, I can confirm that Mr. Washington is eligible for public defender services.
Right, I'll make a finding of probable cause, get the not guilty plea entered, state's position on bail.
State's requesting a signature bond with conditions that the defendant not direct any acts or threats of violence towards Linda W. or any member of her family. Further, that the defendant be banned from the 1800 block of Whitney Way in Madison, in that he not possess or use any dangerous weapons as that term is defined by statute.
Any objections?
We would not object to the signature bond, not object to the ban on dangerous weapons and the no acts or threats of violence condition, but I do have to object to the address ban. One thing I want to make very clear to this court is that Mr. Washington is 17 years old. In fact, only turned 17 years old just a couple of weeks ago, meaning he's only been able to be brought into adult court for a few weeks now. That is where he lives, and that is where he lives with his family. At 17 years old, I'm not sure that Mr. Washington has anywhere else he could go. He has no criminal record that I'm aware of. If that address ban is put in place, my concern is that a 17-year-old who's still attending high school is going to be left on the streets, or at the very least have nowhere safe that he can go. So I would object to the address ban. It strikes me as unnecessarily punitive given Mr. Washington's age. Thank you.
All right, and the clerk just popped me up that there's a 72-hour no contact that's enforced. He can't go back there regardless of what I decide until March 4th at 11:28 a.m. And that was enforced by the victim, Linda W. Any response from the state?
Your Honor, I will say that our office has been in communication with the victim. There are other children that reside at the residence. The victim does not feel safe with the defendant returning. She feels for, of course, she enforce the 72 no hour and, worries for not only her safety, but also the other children. So I would remain firm on the address ban.
Okay, and any response, Attorney Ventola?
Okay, Mr. Washington has represented that he does have somewhere that he would be able to stay.
Okay, and does he know what that address would be? Off the top of your head? Okay, what is that?
1815 South Winnie Way. How do you spell Way? Sorry, Whitney Way, WHITNEY. That is Madison. 53705. Apartment number 1.
And is there somebody that we could put the notice in care of? Because I'm guessing he's not on the mailbox and the mail might not get delivered.
It's DeMonte Maddox. I assume
All
MADDUX. OX.
right, and DM or DEMONTE.
DEMONTE.
All right. You got all that? All right, given the victim's specific wishes, I'll order the signature bond, I'll order the ban from the 1800 block of Whitney Way. If you do need to get any items from the residents, you'd have to contact law enforcement or have contact with Linda outside of the residence, not in the 1800 block. I'll order the no acts or threats of violence towards Linda W. and that you not use or possess any dangerous weapons. Second. And I'm sorry, I didn't catch the address. So the address is in the 1800 block of Whitney Way
Yes.
that he gave.
I think we originally had 1810, now we have 1850.
Oh, I had heard 19, but that might just be, I might have misheard.
Well, let me ask, the state if the victim has requested a ban from the entirety of the block as opposed to just not wanting him at their home at this time. Perhaps the reasonable response is just to order a ban from the victim's residence and not the entirety of the block. Since she's apparently okay with contact outside of the residence.
I would also just briefly add that these are separate buildings.
Maybe before we get into that, it was 1815 South Whitney Way, apartment 1, correct? I see a head nod for the defendant.
All right, Attorney Bake, any response?
That's correct.
I think that's fair. My notes indicate that she felt strongly about the address ban, but under the circumstances, I think a ban from specific residents makes sense.
All right, I'm gonna modify that to a ban from 1810 South Whitney Way. I don't even need to limit it to an apartment, so you can be at 1815, but don't be going on the property for 1810. It sounds like they're separate buildings. You get in trouble with the bail conditions, you'll get arrested, be right back here, and then they'll maybe ask for cash bail because they'll say, well, Mr. Washington can't fulfill his promises. So I don't want you in that position. We will be adjourned.
Back to you.
Very good. Next up is Keith Morris.
No action threats to Linda W, no dangerous weapons. From 1810 South Whitney. Sorry.
Morris.
Morris?
Okay, I'll see what I can do about the food.
All right, we'll go on the record in the state of Wisconsin versus Keith Morse's 26 CF 513 appearances.
John Make for the state.
Mr. Keith Morse appears by Zoom video conference from the Dane County Jail. Appearing in person is attorney C. Joseph Antolik. We have received a copy of the criminal complaint. I would waive its formal reading, if I may just have one moment. Mr. Morse, can you give us a thumbs up if you can hear me speaking?
My thumb is up if you can see me.
Yep, Mr. Morse is giving a thumbs up indicating that he can see us and I am able to hear him. Mr. Morse, I have a mailing address of 333 West Dayton Street, apartment 501. Is that a good mailing address for you, sir?
Yes.
Okay, so we can confirm that the mailing address on the criminal complaint is correct. And at this time, I'm not able to verify his eligibility for public defender services. We would also stand mute as to the misdemeanor charges. Thank you.
Great. I'll make findings of probable cause and are not guilty pleas to the misdemeanors. State's position on bail.
State's requesting $1,000 cash bail with two conditions. First, that the defendant not operate a motor vehicle, and second, that he not possess any drug paraphernalia. This is of course a flea elude. The defendant was allegedly speeding approximately 50 miles per hour in a 25-mile-per-hour zone, eluding cops. Cars parked on both sides of the street. The law enforcement officers ultimately had to terminate the pursuit, presumably for safety reasons. He also does have two open cases here in Dane County, 25 CM 2159 and 25 CM 2177. Given all these facts, I think a significant amount of cash is necessary because Mr. Morse has demonstrated that he's not willing to stop for law enforcement. Therefore, his failure to appear risk becomes higher.
And Attorney Ventol.
I would ask the court to consider a lower amount of cash bail, perhaps $500. I would note that Mr. Morse has no criminal convictions on his record. As for the cases 25 CM 2177 and 2159, it is noteworthy that he has made all his appearances on those cases. I say that because the offenses that he is facing today are not Act 3 eligible. So ultimately what the court is considering is an amount of cash that would bring Mr. Morse to come to court. He has at least shown on his other open cases that he will come to court. But I recognize that given some of the allegations here, there will be some concern. So I would ask the court to consider a lower amount of cash. Thank you.
All right, well, there's some things in his favor. He's made his court dates in less serious cases. Quite frankly, I don't think the request for $1,000 would be out of line if he wasn't out on bail on anything and had no prior criminal record, given the eluding behavior. When I take into account he was already on bail, this is not the first time he's been stopped by law enforcement, and then he allegedly does this. I think the $1,000 is the least that's appropriate. I'll order that. I'll order that he not operate a motor vehicle at all, and I'll order that he not use or possess controlled substances or drug paraphernalia without a valid prescription. I think the request was just with respect to paraphernalia, but to me, they kind of go hand in hand.
Can I say something, please?
Well, you probably don't want to, Mr. Morse. Anything you say is going to be recorded and taken down, to be used against you later on.
Well, I'm comfortable with that, and I want to speak anyway.
Mr. Morse, I would really have to advise you not to do that because it's one of the easiest ways to shoot yourself in the foot.
Well, I'm going to disregard your advice. I was using hemp, and I purchased it from a retail establishment on Johnson.
Mr. Morse, I'm really going to have to advise you to stop speaking.
Okay, then I will. I do have to say one other thing. I have $1,000 in my account, in my bank account, and I can post, but I would need to get access to my phone so that I could transfer the money to my debit card, and then I could actually use it to post bail if I would be allowed to do that.
That's going to be up to the jail.
Yeah, I mean, I can possibly do that, but I would just need to be able to transfer the money to my debit account and then just use my debit card.
That's going to be in their hands. I don't have any authority over that. They get to run the jail and the safety protocols there. So, Mr. Morse, it sounds like we should probably just get a prelim set within the next 10 days. That way, if you're not able to get the $1,000 cash bail, you can have the bail reviewed is you're eligible for a public defender, so somebody can file a motion on your behalf. And we'll make sure you have their contact information. That would be a free call from the jail.
I would just briefly correct the record, unless the court has some information that I do not. I am not able to or verify his eligibility for a public defender. So he might be, he might not be.
Okay, so you got to apply in every case, Mr. Morse. If you were eligible previously, you're probably going to be eligible in this case, but you got to reapply in every case. So give them a call to see if you're eligible. You're certainly free to hire a lawyer on your own if you're able to do so. But we'll get a prelim set in the next 10 days in case bail needs to be reviewed. We are adjourned.
Question though, how do I call?
I don't know. I can't give you advice, and what you've proposed is going to be up to the sheriff as to
Okay,
whether they
okay.
allow that. I have no control over the jail policies or procedures.
Next up is JEREL SCOVILLE for a forfeiture.
I don't know about that.
You have to sit down.
I get to sit down.
All right, we'll go on the record in the County of Dane versus JEREL SCOVILLE. It's 26FO3781 appearances.
John Bake for the county. Defendant appears in person in custody without counsel.
All right, and Mr. Scoville, the good news is you're not getting charged with any crimes. They charge you with county disorderly conduct. That's non-criminal. It's more like a speeding ticket. I don't see anything else that's holding you, so I believe you're going to get released today no matter what. That said, they are going to have an offer. If you want to accept that offer, then you can be done with the case. If you don't, you're still going to get released, but you'd have to show up for future court dates, okay? Is there an offer?
Yes, the county's offering court costs.
That'd be $114.50. It's not something you have to pay up front like bail. You'd have to pay that in the next 60 days or work out a payment plan if you need more time. Did you want to accept that, or do you want to confess the charges?
I'll accept.
Okay, I'll judge you guilty of county disorderly conduct based upon the no contest plea. Order a court cost of $114.50. They'll give you some info about making those payments, and we'll be adjourned. Yep, you're welcome.
Next up is Michael Arbuckle, appearing by Zoom.
Great, we'll call the state of Wisconsin versus Michael Arbuckle Jr. It's 26 CM 486 appearances.
John Bake for the state.
Mr. Michael Arbuckle appears by Zoom video conference. Appearing in person on his behalf as attorney C. Joseph Antola. Mr. Arbuckle, can you give us a thumbs up if you can hear us? Mr. Arbuckle appears to be giving a thumbs up. Mr. Arbuckle, would you like to use the beacon as your mailing address? Just give me a thumbs up if that's okay. He has indicated that he would like to use the beacon as his mailing address. So with that said, we have received a copy of the criminal complaint. I would waive its formal reading, and I can confirm that the mailing address on it is correct. Stand mute as to the misdemeanor charges, and I can confirm that he is eligible for public defender services. Thank you.
Great, I'll make findings of probable cause and are not guilty, please. State's position on bail.
State's requesting a signature bond with conditions that the defendant have no contact with Eric F, ERIC, Kim W, or Roosevelt W. That he be banned from the Walgreens at 3710 East Washington, and that he not expose genitalia in public.
All right, any objections?
I suppose I would really only object to the last condition. That is itself just another lewd and lascivious crime. So if he were to do that again, he would already face a charge for lewd and lascivious and face a charge for bail jumping for committing a new crime. I don't think it's necessary to have that as an additional condition. Thank you.
All right, any response from the state?
No.
Well, I'll order a signature bond. I'll order no contact director and direct with Eric F, Kim W, and Roosevelt W. I'll order a ban from Walgreens at 3710 East Washington Avenue. I think the exposure actually has additional elements beyond that. So I think they actually have asked for a bail condition that isn't just a complete restatement of the crime itself. So I will order that he not expose his genitalia in public, and we'll be adjourned.
Next up is Stephen Willems for a forfeiture.
Go on the record in the County of Dane versus Stephen Willems, it's 26 FO 376 appearances.
John Beck for the county. Defendant appears in person, out of custody, or in custody without counsel.
All right, and Mr. Willems, you're not getting charged with a crime. They charge you with county disorderly conduct. That's a non-criminal matter. It's more like a traffic ticket. It's not going to keep you in custody. I don't think anything else is keeping you in custody, so I believe you're going to get released yet today. They will have an offer, though. If you want to accept the offer, then you can be done with the case. If not, you'll still need to show up for future court dates, but it's not going to affect your custody, okay? What's the offer?
County is offering court costs.
That'd be $114.50. It's not like bail that you have to post, but you would have to pay that within the next 60 days or work out a payment plan. Did you want to accept that offer? Or do you want to contest the charges?
I'll accept that.
Okay, I'll judge you guilty based on your no contest plea to the charge. Or you pay the court cost of $114.50. They're going to give us some info about making the payments and we'll be adjourned.
I I have to pay it before I get released, right?
No.
Okay.
You have to pay it within the next 60 days. It's not like bail because you didn't get charged with a crime. So this is like paying a ticket.
All right, thank you.
Yeah, and if you need more than the 60 days, just contact the clerk of court's office and arrange for a payment plan, okay?
All right, I appreciate it.
Yep, you're welcome.
And Sandy Moore, hearing by Zoom.
And sorry, what was the name?
Anthony Moore.
Anthony. Oh.
We'll go on the record in the state of Wisconsin versus Anthony Moore. That's 26 CF 509. We also have a bail hearing in 26 CF 326 appearances.
John Beck for the state.
Mr. Anthony Moore appears by Zoom video conference from the Dane County Jail. Attorney C. Joseph Ventola appearing in person. Mr. Moore, can you give me a thumbs up if you can hear me? Mr. Moore has given me a thumbs up indicating that he can hear me, and because I have a note on my sheet here, I should ask. Mr. Moore, I have an indication that you do not want SPD representation today. Can you give me a thumbs up if that is correct? Mr. Moore is indicating that he would not want to be represented by the SPD. I will just ask as a final question, Mr. Moore, are you comfortable with me representing you today? If you are comfortable with me representing you, give me a thumbs up. If you are not, please give me a thumbs down. All right, he's giving me a thumbs up indicating he is okay with me representing him for today's purposes. And I would ask one last thing directly to Mr. Moore. Mr. Moore, I have a mailing address for you listed as the Beacon. Is that a good mailing address for you? Just give me a thumbs up if it is. Yes, it is. Okay, so I got another thumbs up from Mr. Moore. With all of that done, I would say that we have received a copy of the criminal complaint. We would waive its formal reading. I can confirm that the mailing address on it is correct. And I'm just double checking if there are misdemeanor charges. I believe on one of them there is. Yes, stand mute as to the misdemeanor charges. And I'm not able to verify his eligibility for SPD representation on the new cases.
Okay, so Mr. Moore, you have the absolute right to an attorney after today. It sounded like maybe you didn't want the public defender going forward. But if you change your mind, we'll make sure that you have their contact information. But if you're able to hire an attorney after today, that's certainly fine. I'll make a finding of probable cause in the new case. Enter not guilty pleas to the misdemeanors, state's position on bail.
State's requesting $500 cash bail on each case. As it goes to the IA in 26 CF 509, state's requesting the condition that the defendant have no contact with Jackson K. Here, the defendant was granted a signature bond in the earlier case, 26 CF 326, just a few weeks ago. He failed to appear not too long ago for a preliminary hearing, and despite being on bond, he continues to commit crimes. In this case, allegedly threatening law enforcement officers when they respond to his behavior. His behavior is demonstrating, as well as his failure to appear, is demonstrating why some cash is necessary.
Right, and Attorney Ventola.
I don't have much information on Mr. Moore, but what I will say is that if someone is using the Beacon as their mailing address, that indicates that they are very, very poor. I mean, my understanding would be that Mr. Moore is quite likely homeless if he is receiving his mail at a shelter. $500 cash on each of the cases is a pretty high amount for someone who is homeless to be able to post. So I'd ask the court to consider a lower amount of cash. I know that there will be some concerns, given that there are felony charges here, maybe an amount somewhere around $100 or $250 per case. I don't have much more information on Mr. Moore than that, but I would emphasize his indigency and would ask the court to take that into consideration when making a bail determination today. Thank you.
All right, thank you. Well, I appreciate the argument for a lesser amount of cash bail. I think it is a cash bail case. He was out on an Act 3 case. He's picked up new Act 3 eligible charges, failed to appear in court. I'm just not somebody who typically sets a token amount of bail, which I consider $150 to be a token amount of bail. I think in 26 CF 509, given the battery and then the additional felony charges related to law enforcement, the incentive not to appear is greater there. I'll set $500 cash bail there. Order no contact direct from Director Jackson K. In the earlier case, I think $200 is sufficient. When I add that with the 500 in the other case to get him to appear, I'll order that with the prior non-monetary conditions there. And he missed the prelims, so I assume he wants prelims on both of these in the time limits.
I would assume that Mr. Moore wants prelims within the time limits. Thank you.
Okay, Mr. Moore, it won't give you a lot of time to get a lawyer, so if you're not going to get the public defender's office, make sure you retain somebody as soon as possible. We're adjourned.
Next up is Jermaine Peoples.
We'll go on the record in the state of Wisconsin versus Jermaine Peoples. It's 26 CF 505 appearances.
John Bake for the state.
Thank you, Judge. Mr. Jermaine Peoples appears in person and in custody alongside Attorney C. Joseph Ventola. We have received a copy of the criminal complaint. We would waive its formal reading. I can confirm that the address on it is correct. And it would appear that Mr. Peoples is eligible for public defender services at this time, and he currently has public defender representation.
All right, I'll find probable cause and are not guilty pleas to the misdemeanors. State's position on bail.
State's requesting $500 cash bail with conditions that the defendant have no contact with his co-defendant Michael Rowe and that he be banned from all Walmarts. Your Honor, the defendant currently has 2 felony cases open to my understanding, with a total of, I believe, $800 cash bail across the 2 of those cases. Here it's alleged that he gave a false name to officers, and then he admitted to doing so as he thought he had warrants open for his cases. He does have a failure to appear last year in December as well.
All right, and Attorney Ventola.
I would ask the court to consider a lower amount of cash bail, maybe in the realm of $250. Mr. Peoples does currently have SPD representation indicating that he is indigent. And of course, he's been deemed eligible for public defender services on this newest case. $500 is a significant amount of cash bail to post. I know he has posted cash on his other cases, but there's only so much cash that someone who is indigent can get together. In support of this request, I would note that he has significant ties to the community. He has lived in Dane County for his entire life. He has his parents and his friends all living here. And it's my understanding that he relatively recently was employed here in Dane County. These are nonviolent offenses. They're not Act 3 eligible, which is to say the court is considering an amount of cash that would get him to come to court. I think $250 would be appropriate. Thank you.
All right. Well, I think this is the least serious of the cases he has. The other ones are actually felonies, not just based on the fact that he's out on felony bond like this one. The prior failure to appear, the fact that he's picked up a 3rd case, he's lying about who he is because he thinks he has a warrant, rather than turning himself in if he thought he had a warrant. all lead me to believe that some cash is necessary to ensure appearance. It looks like $300 in one of the cases was sufficient. I think it'll be sufficient here. I'll set $300. I'll order no contact direct with your co-defendant, Michael Ware, and that should be banned from all Walmarts. He would be entitled to a preliminary hearing in 20 days. What's his position on that?
It's Michael Rose.
Oh, Michael Rose, sorry.
It looks like there's already a prelim scheduled for March 12th. That would be.
Okay, so if he wants to enforce the time limits, we'll just get this set with his other case. Next week.
You got one here on the phone. He'll enforce the time limits and have them all on the 12th. Thank you.
Yep, makes sense. We'll be adjourned. Yep, that's what we'll do. We are adjourned. Take care.
Next up is Ryan Spence, hearing by Zoom. Just to inform the court, we've been informed that Spence is declining to participate.
All right, we'll go on the record in the state of Wisconsin versus Ryan Spence is 26 CF 514 appearances.
John Vick for the state.
Attorney C. Joseph Ventola appearing in person for Mr. Ryan Spence, is my understanding, has declined to participate. I will say for the court that I do represent Mr. Spence on the other open cases he has. And Mr. Spence and I actually generally have a very strong working relationship. Oh, maybe he is participating. Ryan, can you hear me? Give me a thumbs up if you can hear me.
I'm not participating in this bullshit. I am not represented by no lawyer. Get out of the face. I am not playing this bullshit. Get away from my door. Bye-bye. Not represented. I'm fired.
Okay.
Joseph Ventola is fired. Bye-bye.
Okay, I think we should probably mute him because he keeps walking away and coming back, and we're not going to be able to hear Attorney Ventola.
I guess I should point out the last line that I heard was Attorney Ventola is fired. That seemed pertinent to this hearing.
We'll discuss that one-on-one with Mr. Spence. Again, we generally have quite a good working relationship. I suppose I cannot verify if Mr. Spence has received a copy of the criminal complaint. I do believe that generally the Beacon is a good mailing address for him. I mean, if the deputies would allow it, I would like an opportunity to speak to Mr. Spence about this newest
Yeah.
case.
They can either take you down there or set you up with a laptop to try and speak with him.
And it might be good to clarify
Sure,
what he wants.
Yeah.
Thank you.
we can do that. We'll take a brief recess to do that. Maybe we'll do some forfeitures in the interim.
Okay.
All right, we'll go on the record in the County of Dane versus Leah Foster. It's 26 FO 372 appearances.
John Vick for the county. Defendant appears in person in custody without counsel.
All right, and Ms. Foster, you're not getting charged with a crime. They charge you with county disorderly conduct, so that's non-criminal. It's more like a speeding ticket as far as severity. So you're not going to be held in custody after today. I don't see anything else that's holding you. You're going to get released today no matter what. They are going to have an offer, though. If you want to accept the offer, then you can just be done with this new case. If not, then you'd have to show up to future court dates, but you're still going to get released today no matter what, okay?
I have a question. Do I not have resisting?
They didn't charge that. It's just a county disorderly conduct charge, which is non-criminal. What's the offer from the county?
County's offering court costs.
Okay, so if you wanted to accept that offer, you'd have to pay $114.50 in the next 60 days or work out a payment plan if you needed more time. Did you want to accept that offer? Or do you want to contest the charges?
I'll let it set.
Okay, I'll judge you guilty of county disorderly conduct based upon the no contest plea. Or do you pay the court costs of $114.50? They're gonna give you the info about making the payments and you'll get processed and released yet today, okay?
Release today,
Yep, I don't see anything else holding you, so.
so in 60 days, I have to pay 100.
Yeah, it's not like bail. You don't have to pay it up front to get released. You just have to pay it in the next 60 days. Or if you need more time, contact the clerk's office and they can arrange for a payment plan to extend it beyond the 60 days if you need more time.
All right.
Any other questions? Okay. Timothy Rogers. Hold on, all right. We don't have.
RUNKE.
Your paperwork, sir, please $70.
Great, we'll go on the record in the County of Dane versus Travis RUNKE. It's 26 FO 375 appearances.
John Big for the county. Defendant appears in person in custody without counsel.
All right, and Mr. Runke, you're charged with county disorderly conduct. That's non-criminal. It's more like a speeding ticket as far as severity. It's not going to affect your custody. I think you're going to get released today. I don't see anything else holding you. But it is the type of case where they'll actually have an offer. If you want to accept the offer, then you can be done with it, okay? Is there an offer?
Yes, the offer is court costs.
All right, so if you wanted to accept that, you'd have to pay $114.50. It's not like bail, you don't have to pay it up front, but it's $114.50, either in the next 60 days or work out a payment plan. Did you want to accept that? Yeah. Okay, I'll judge you guilty of county disorderly conduct, or you pay the court cost of $114.50. They'll give you the info about making the payments. Any questions?
Yeah.
Okay, we are adjourned.
Right this way?
We'll go on the record in the County of Dane versus Timothy Rogers Jr. It's 26 FO 374 appearances.
John Big for the county. Defendant appears in person in custody without counsel.
All right, and Mr. Rogers, the good news is you're not getting charged with a crime. They've charged you with county obstructing, resisting an officer. That's non-criminal. It's more like a traffic ticket. And I don't think anything else is holding you. So I believe you're going to get released today no matter what, but they will have an offer. If you want to accept that offer, then you can just be done with the case. If not, you're still going to get released, okay? And the offer?
County's offering court costs.
So if you wanted to accept that, sir, it'd be $114.50. You have to pay that in the next 60 days or work out a payment plan with the clerk's office. Did you want to accept that? Pardon? It's $114.50 if you wanted to accept their offer and enter a no contest or guilty plea to the charge, and then you'd be done with the case.
I don't know, can I decide?
Yep, I'll enter a not guilty plea at this point. You're gonna get released from jail anyways. And they usually keep the offer open until the pretrial conference. If you don't accept it by then, they probably will withdraw that. I do need to advise you that if you want to preserve your right to a 6-person jury trial, you do need to make a written demand within 10 days of today's date and post $36 in non-refundable jury fees. And do we have a good address on your complaint? I've got 1717 Taylor Avenue, Racine, Wisconsin.
Yes.
Yes? Okay, we are adjourned.
So I'm sorry, this way, please.
All right, I think we're all set to go back on the record in Ryan Spence's case, 26 CF 514 appearances as before. And Attorney Ventola, or you had a chance to speak to Mr. Spence?
I did have a chance to speak with Mr. Spence. He has decided that he is actually comfortable with me continuing to represent him both today and in the future. And I have gotten his position on bail. He is requesting a lesser amount of cash bail. I understand that given the number of cases that he has and given that there are felony allegations here, the court is going to be considering this as a cash bail case. I actually have quite a bit that I can say about Ryan Spence because I
think that we had just gotten to the point of maybe confirming that he could hear us and about his representation before. I don't know if we gotten through.
he was able, oh, sorry, yes. He was able to hear us. While he does not want to necessarily participate directly in the hearing, he did express that he is comfortable, again, with my representation of him today and my continued representation of him in the future.
Yeah, and I'm not sure if we got a waiver of the reading of the complaint and confirm the address and.
No, that is correct. I don't even think we got that far. So the address on it is correct. We would waive formal reading of the complaint, stand mute as to the misdemeanor charges. And he has not specifically verified his SPD eligibility on this case, but given that I'm appointed to his other cases, I believe he's likely to be SPD eligible.
Okay, we'll make sure he gets the contact info and Mr. Spence, in order to get Attorney Ventola after today, you're gonna have to give them a call or stop by their office to see if you're eligible on this case as well. I'll make findings of probable cause, enter not guilty pleas to the misdemeanors and state's position on bail.
State's requesting $1,000 cash bail with the condition that the defendant have no contact with Officer Shiro, SCHIRO, except in the officer's official capacity. Here, this is the defendant's sixth pending case. I believe he's posted $550 cash bail across his 5 other cases. He continues to commit crimes. This case is a felony. Clearly, a significant cash bail is necessary.
And just to clarify, when you say 550 across his other cases, that's the sum total of all of those, so relatively modest cash bails in all those cases?
Yes, my understanding when I looked at it earlier was that 3 of them were signature bonds, and then 2 cases were cash bonds, one for $250, the other for $300.
Okay, and Attorney Ventola?
Again, I understand that the court's going to be considering cash bail, given the number of charges here, given the number of open cases, and given the fact that there is a felony charge here. But I would be asking for a lower amount of cash bail, maybe in the realm of $500. As I was beginning to say until thank you for correcting me. I know Mr. Spence quite well from my representation of him. He is a lifelong Dane County resident. He grew up with his grandparents due to a pretty tumultuous living situation with his parents. He went quite a while without getting into any trouble. If I recall correctly, his last cases before the last year were 2018. And what had happened to Ryan was that he was in a sober living facility that was, or it was a sober living facility or a halfway house, I actually don't recall, where he was doing very well. He was staying out of trouble, and he was getting treatment for, among other things, a traumatic brain injury that he has. And then he was, I don't know why, but he was kicked out of that home, and he's been living on the streets ever since. What we're seeing with Mr. Spence now, the allegations against him now, are not atypical for someone who is living on the streets, who is struggling with addiction, and who is struggling with his mental health. While I do believe, based on my extensive interactions with Mr. Spence, that he is competent to proceed, he does have significant mental health conditions that make his time in the Dane County Jail, I'll just say it, traumatic. You know, we saw him very upset at the beginning of this hearing, and that's because he's in segregation. He is taken off the streets where I wouldn't say he's doing great, and he's put in a segregation unit, which is even more distressing for someone with Mr. Spence's conditions. Ryan and I do have a very good working relationship. We were able to talk through some of the concerns that he expressed at the beginning of this hearing. He stays in contact with me regularly, and on his set of cases from 2025, he not only did he stay in contact with me after he was released from custody, but he did make his scheduled court appearances. I believe that a lower amount of cash bail would be appropriate for Mr. Spence under these circumstances. And, you know, lastly, I should mention that, of course, he is indigent. He is homeless. I know for a fact that Ryan Spence is homeless. He quite literally sleeps on the sidewalk, on the streets. $1,000 cash bail is a really significant amount for someone in his circumstances to post. So I'd ask the court to consider a $500 cash bail, recognizing both the number of open charges and the nature of the new charges. Thank you.
All right, yeah, well, I think in looking at CCAP, he's got 6 cases all filed in 2026, just posted $300 the other day. In one of those cases, there's a PSA in one of those prior cases from this year recommending cash bail, showing he's failed to appear in the last 2 years at the time of that PSA, failed to appear older than 2 years and put him at almost the top of the scale on both metrics. He's 5 out of 6 on failure to appear. I see it as a cash bail case. I think it is more serious than the misdemeanor cases that he's got pending this year. It's also an Act 3 eligible offense. I'm willing to set it a little bit less, but not much. I'll set it at $750. Order no contact direct or indirect with Officer Shiro except as necessary in the ordinary course of his duties as law enforcement officers. And I guess the upshot of the bail is he would be entitled to a prelim in the next 10 days if you'd like to get that scheduled.
I do not believe that Mr. Spence wants to waive those time limits. Thank you.
Okay, we'll get it scheduled and we'll be adjourned.
Next up is Jamal Jefferson.
Ryan, I'll call your uncle.
Sorry about interrupting you, right?
No, that's okay. I totally forgot that John hadn't actually put it on the record yet. I was just like, all right, I'm ready to go. No, thank you. You have to do it, you know.
On the record in the state of Wisconsin versus Jamal Jemison, 26 CM 506 appearances.
John Bake for the state.
Mr. Jamal Jemison appears in person and in custody alongside Attorney C. Joseph Antola. One moment, please.
Yes.
Okay. We have received a copy of the criminal complaint. We would waive its formal reading, stand mute as to the misdemeanor charges. I also can confirm that the address on it is correct. I just have one quick question for Mr. Jemison. So I'm from Are you okay with me representing you just for today? Okay. All right. I did have a note that Mr. Jemison did not want SPD representation, but he is comfortable with my continued representation of him, at least for today's purposes. But other than that, I cannot verify his eligibility for public defender services. Thank you.
Okay, so sir, I think they've given you the public defender info. If you change your mind and you're not able to hire private counsel, you can give them a call and see if you're eligible. I'll make a finding of probable cause and or not guilty plea on Mr. Jemison's behalf. There is a public safety assessment report and it recommends a signature bond. State's position on bail.
State requests a signature bond with the condition that the defendant not use or possess any dangerous weapons as that term is defined by statute.
Any objections?
No objections. Thank you.
Okay, I'll order a signature bond. Condition will be that you not use or possess any dangerous weapons as that term is defined by the state statutes and we'll be adjourned.
That's for you. Good luck to you.
Next up is Jeffrey Thompson.
On the record, in the
Mr.
state
Jeffrey
of
Thompson.
Wisconsin versus Jeffrey Thompson, 26 CF 519 appearances.
John Bake for the state.
Just a moment. Oh, is it down? Yes. Oh. Mr. Jeffrey Thompson appears in person and in custody alongside Attorney C. Joseph Antola. We have received a copy of the criminal complaint. We would waive its formal reading, stand mute as to the sole misdemeanor charge. I would also say that the mailing address on it is not correct, but I do have a good mailing address for Mr. Thompson. It is 7 Sherman Terrace, Unit 2, Madison, Wisconsin, 53704. And it appears that he is eligible for public defender services. Thank you.
All right, I'll make a finding of probable cause for the charges. There is a PSA report. It recommends cash bail. What's the state's position on bail?
State recommends a signature bond with the condition that the defendant have no contact with Barry B as in boy.
Any objections?
No objections. Thank you.
All right, looks like maybe he got arrested at the courthouse. Is that right?
Yes.
All right, well, that's a pretty good indicator as far as risk to not appear. I'm concerned what the PSA says. I've got a joint recommendation. I'll go along with it. I don't think you're gonna get a lot of leeway if you miss any court dates or you're picking up any more cases. given the history. So I'll order the signature bond, no contact director and direct with Barry B. And you have the right to a prelim in the next 20 days. State's defense position on that?
Mr. Thompson has indicated that he will be waiving the time limit.
Okay, we are adjourned.
Good luck to you.
Next up is Kim Gardner. Watch your step. Watch your step. No worries.
Okay, we'll go on the record in the state of Wisconsin versus Kim Gardner. It's 26 CM 493 appearances.
John Bake for the state.
Where's that bet?
Ms. Kim Gardner appears in person and in custody alongside attorney C. Joseph Fantola. We have received a copy of the criminal complaint. I would waive its formal reading, stand mute as to the misdemeanor charges, and the mailing address on it is correct. I am also unable to verify her eligibility for public defender services at this time.
Right, and Ms. Gardner, the deputies handed you the public defender info. If you can't hire an attorney on your own, give them a call to see if you're eligible. I'll make findings of probable cause, enter not guilty, please, state's position on bail.
State's requesting a signature bond with the conditions that the defendant be banned from the Meritor Hospital except for legitimate medical emergencies, and that she not consume or possess any alcohol.
Any objections?
No objections to any of the conditions proposed by the state or the signature bond. Thank you.
Okay, I'll order a signature bond. Condition will be that you be banned from Meritor Hospital except for legitimate medical emergencies and that you not possess or consume any alcohol, and will be adjourned.
So,
All right. Good luck to you.
this Gardner, this way. It's the moment. As a guy in the sign. He is done. So.
It's not up to me, sorry.
Next up is Mikel Ross. Ross?
Oh.
Yellow.
We'll call the state of Wisconsin versus Nikhil Ross. It's 26 CM 489 appearances.
John Bake for the state.
Yep, okay. Mr. Nikhil Ross appears in person and in custody alongside attorney C. Joseph Fantola. I've received a copy of the criminal complaint and would waive its formal reading. I can confirm that the mailing address on it is correct, and it appears that Mr. Ross is eligible for public defender services. Thank you.
Right, I'll make findings of probable cause and are not guilty pleas to the charges. The PSA report recommends a signature bond, state's position on bail.
State requests a signature bond with conditions that the defendant have no contact with Terrace G, TAARRIS, and that she be banned from the 2000 block of Zeer Road, ZEIER.
Any objections?
No objections. Thank you.
Okay, we'll order a signature bond. Condition will be that you have no contact, direct or indirect, with Terrace G. That should be banned from the 2000 block of Zaire Road. And yes, sir.
So like. You guys also offer community service, because I'm actually looking for something to do with it.
Well, so right now, we're not resolving the case. This is just the bail. And there's going to be a pretrial. You'll find out what the offer is. you and your lawyer will have a chance to negotiate the terms of any resolution. So it's a signature bond. There's no bail or cash that you have to post. You're just gonna sign and you'll get released. Okay? Any other questions, sir? Okay, we are adjourned.
Good luck.
All right. You need to go back over here. Next up is gonna be tomorrow, CORTEZ-FLORES. CORTEZ-FLORES. Yeah, Fred, I think this is one for you.
Mr. Cortez.
Yes.
And so we have, Mr. CORTEZ-FLORES is today. We wanna make sure it's tomorrow.
No la iglesia.
Usted es Mauro CORTEZ-FLORES. ¿Usted no es Mauro?
Sí.
Porque hay otro CORTEZ-FLORES aquí también. Es tu hermano. Sí.
Ustedes.
The other guy's my brother.
Okay, we got the right one. Let's go on the record in the state of Wisconsin versus Mauro Cortez-Flores. It's 26 CF 516. Appearances.
John Bake for the state.
Mr. Mauro Cortez Flores appears in person and in custody alongside attorney C. Joseph Antola. We have received a copy of the criminal complaint. Given that there is a language barrier, I would ask that the criminal complaint be read to Mr. Cortez Flores. And just for efficiency's sake, before the court does that, one moment. The mailing address on the complaint is correct, and I can verify that he is eligible for public defender services.
All right, and sometimes attorneys are willing to just have the interpreter read the charges as opposed to the ADA reading in English and then the interpreter interpreting in Spanish. Is that sufficient?
I'm comfortable with Fred reading it.
And since they are both the same charge and penalty, same offense date and location, except for the case number, does he need to read both of them, or can you just read one of them and indicate he has 2 counts?
I would say both of them read that mention that there are 2 counts, and then just mention the cases that he had the conditions on.
Okay, Fred, if you're able to read those.
Parece que usted tiene 2 casos anteriores de Mauro Cortez-Flores, en el caso 25-2847 y este otro caso en 25-2076. Y se agrega que el día lunes 2 de marzo en el pueblo de Fitchburg, después de ser acusado de haber cometido un delito grave en el caso del condado de Dane el acusado había sido liberado bajo el estatuto 969, pero intencionalmente falló en cumplir con las condiciones de esa fianza, no consumir ni poseer alcohol, que está en contra de estos estatutos del estado de Wisconsin. Es un delito grave de clase H y puede resultar en una multa de $10,000 en cárcel por hasta 6 años o ambas cosas en los 2 casos estudiados. The interpreter just finished reading counts 1 and counts 2 for felony bail jumping to the defendant.
All right, appreciate that, Mr. Svensson. We have a certified interpreter, Fred Svensson. He's already been sworn for our hearings today. And was he going to be eligible for a lawyer?
It appears that he is eligible for public defender services, yes.
All right, I'll make findings of probable cause. State's position on bail.
State requests a signature bond. Condition that the defendant not consume or possess any alcohol.
No objection, thank you.
I assume that would be the case since he does.
This is a current.
Oh, I'll order a signature bond. And the condition will be that you not possess or consume any alcohol. What about time limits?
They will not be waived.
Okay, so we are adjourned.
Next up is Casey Perez Lorenzo. Right.
Cortes Fonseca Morris. Oh, 516. You're very welcome, Fred. Thank you.
Perez Lorenzo is the last name.
You. Tenemos su denuncia aquí, se llama Casey Yomari Pérez Lorenzo.
Right, we'll go on the record in the state of Wisconsin versus Casey Perez Lorenzo, 26 CM 501. Appearances.
John Bay for the state.
Miss Casey Perez Lorenzo appears in person and in custody, alongside attorney C. Joseph Ventola. One moment, please. No, it's okay. We have received a copy of the criminal complaint. We will not be waiving formal reading, and we can have Fred read it directly to Ms. Perez Lorenzo. But before we do that, I would just say that the mailing address on it is correct. We would stand mute as to the misdemeanor charges. And it would appear that Ms. Perez Lorenzo is not eligible for public defender services.
Okay, and Mr. Svensson, if you're willing to read the charges to her in Spanish, I'd appreciate that.
Your Honor, there are many charges, or any duplicative like the other one?
So it's gonna be count 5 and count 8 are the only ones that apply to her.
Got it, I will read count 5 and count 8. Dice aquí que se alega que usted cometió una conducta desordenada en cargo número 5 y el cargo número 8, resistencia a oficial. Se alega que el día 28 de febrero, sábado, en Madison, Wisconsin, en un lugar público, usted participó en un comportamiento que pudiera haber sido violento, abusivo, simple, vulgar, malicioso o ruidoso, y o de otra manera desordenada en su comportamiento, algo que está en contra de los estatutos estos, es un delito menor de clase B. Al ser condenada por este cargo, puede resultar una multa de $1,000 o 90 días de cárcel. Y resistencia a un oficial. El día 28 de febrero también se alega que usted resistió a un oficial mientras que el oficial estaba actuando en su trabajo como un oficial, en su capacidad oficial con la autoridad legal. Resistió usted su arresto, algo que está en contra de los estatutos del estado de Wisconsin, es un delito menor de clase A. Al ser condenado por este cargo, puede resultar en una multa de $10,000 y 9 meses de cárcel como castigo máximo. The interpreter has finished reading counts 5 and counts 8 for the defendant.
Thank you. I'll make a finding of probable cause for the charges that apply to this defendant and are not guilty pleas on her behalf. State's position on bail.
State requests a signature bond. Conditions that the defendant have no contact with her co-defendants, Naomi Castro, Edith Julissa Juez Portillo, and Atiana Alexandra Rodriguez. Further, that she have no contact with Officer Joy, except Joy, J-O-I, except in his official capacity, and that the defendant be banned from the Soto nightclub, SOTTO, which is located on North Henry Street in Madison.
Ella es mi amiga, a ella era que yo estaba defendiendo. A ella era que yo estaba defendiendo por eso. La vamos a
We would not be objecting to the signature bond. We would not be objecting to the ban from Soto nightclub. We will be objecting to the ban on talking to her co-defendants. My understanding is that Ms. Perez Lorenzo is quite close friends with the other co-defendants, and she believes that there could be some affirmative defenses, possibly self-defense or defense of others that were at play here. And I don't believe that there were any accusations that the co-defendants were violent toward each other at the very least. So I'd ask the court to take that into consideration, but we're not objecting to the other proposed conditions. Thank you.
Right, and any response?
Well, the allegations here is basically that there was a large fight at the nightclub, and that the individuals here charged here were aggressors. So in other words, they cooperated together. And that's the basis for no contact.
All right, I'm gonna order the signature bond. I'll order a no contact direct or indirect with Officer Joy except as needed in their duties as a law enforcement officer. I'll decline to order the ban on contact with the co-defendants. I haven't heard about a prior history. They're not the victims, they're co-actors. Sounds like there is some reason that she would need or want to have contact with those individuals. I will order a ban from the Soto nightclub. And we'll be adjourned.
One more?
I don't know.
Mauro, not the Mauro, but his brother.
Don't tell me.
I think I was told by the others that the other.
I'll take a quick
Not
and then-
interpreter, but maybe you can. No, the other Cortez does.
Oh, yeah.
Now we Castro does not.
I see.
But who does not?
Castro.
Castro, the defendant co-defendant in this case, with the belief.
Okay.
So what is, next up, we have Gregorio CORTEZ-FLORES.
Okay. And the case number?
26 CT 155.
Thank you.
You're welcome.
CORTEZ-FLORES.
We'll call the state of Wisconsin versus Gregorio Cortez-Flores, 26 CT 155 appearances.
John Bake for the state.
Okay.
Mr. Gregorio Cortez Flores appears in person and in custody alongside Attorney C. Joseph Antola. We have received a copy of the criminal complaint. I will ask Fred to read the criminal complaint to him in just a moment. We would, sorry, I can confirm that the mailing address on it is correct. We would stand muted to the misdemeanor charges, and it appears that Mr. Cortez Flores is eligible for public defender services.
Right, and Mr. Svensson's able to read the charges to Mr. Cortez-Flores, that'd be appreciated.
A tener instalado para y eso yo sé la traducción. Ok, le voy a leer los cargos si quieres explicar cuáles son las condiciones de la hay que esperar así no me va a explicar. Voy a leer los cargos. Entonces dice aquí que se alega que esto ocurrió el 2 de marzo en la ciudad de Fitchburg, en el condado de Dane. Aquí con sus privilegios ya revocados por el Estado, le encontraron manejando una carretera durante ese periodo de revocación y esto puede resultar en una multa de $2.500 y un año de cárcel y 6 meses de revocación de la licencia. Por violar la orden de detener el alcoholímetro, Dice que esto se manejó por este día, que ha sido ordenado, ser eso instalado y esto puede resultar en una multa entre 150 y $600 y hasta 6 meses de cárcel por el primer grado. Es lo que se alega.
Right, and we had certified Spanish interpreter, Fred Svensson, who I swore for our hearings, and you read the charges to him in Spanish.
The interpreter read the charges, count 1 and count 2 in the criminal complaint for the defendant, Your Honor.
All right, thank you very much.
With that, yes.
I'll make findings of probable cause and are not guilty pleas, state's position on bail.
State is requesting a signature bond with conditions that the defendant not operate a motor vehicle without a valid driver's license, and that he not operate a motor vehicle without a functioning ignition interlock device.
Any objections?
No objections to the signature bond, but I would note that given that it is already the law that you have to have a valid license to operate a motor vehicle, and given that my understanding is Mr. CORTEZ-FLORES is subject to an IID requirement, I think that it's unnecessarily repetitive to impose these conditions. Thank you.
Well, the point is taken. I think it'll serve as a reminder. He's going to get it on his paperwork. So I will order a signature bond in order that he not operate a motor vehicle unless he has a valid driver's license, and he not operate a motor vehicle without a functioning ignition interlock device. Regardless of whether I order it, he could be charged with bail jumping if he were to violate those conditions. And we are adjourned.
Next up is Sharice Langlois, appearing by Zoom for a forfeiture.
Fred's good to go then?
Yep.
Thank you, Fred.
Or does Sharice need me?
Hello, we'll call the County of Dane versus Sharice Langlois. It's 26 FO 373 appearances.
John Big for the county, defendant appears via Zoom in custody without counsel.
All right, Ms. Langlois, some good news. You're not getting charged with a crime, so I believe you're going to get released today.
Thank you.
Yeah, well, you should thank the DA's office. They're the one who made that decision. They've charged you with county disorderly conduct, and we'll see what the offer is.
Offers time served.
All right, I don't think I can do that. By statute, I'd have to at least order the court costs, so I'll order $114.50 if you wanted to accept that offer. If you don't, that's fine. You're still going to get released. Ms. Langlois, did you want to accept their offer?
Yeah.
All right, I'll accept that as your no contest plea to county disorderly conduct, or do you pay the court cost of $114.50? They'll give you the info about making payments, and you'll get released yet today. We are adjourned.
Yeah.
All right, next up is Kirk Simmons.
Yes.
Simmons? Hello. Yeah, let's see.
Let's call the state of Wisconsin versus Kirk Simmons. It's 26 CM 495 appearances.
John Big for the state.
On Street 1314 Street. Is it CROW?
Yes.
Okay, and where is that?
That's,
Is it Madison?
yes, it's
All right. Mr. Kirk Simmons appears in person and in custody alongside attorney C. Joseph Ventola. We have received a copy of the criminal complaint. We would waive its formal reading. Mr. Simmons does have a better mailing address than what is on the complaint. He said 1314 Crowley, CROWLEY Boulevard, Apartment 2, and that is Madison. Do you know? 3704. We would also stand mute as to the sole misdemeanor count, and I can confirm that Mr. Simmons is eligible for public defender services. Thank you.
All right, thank you. I'll make a finding of probable cause and or not guilty plea The public safety assessment recommends a signature bond. State's position on bail.
State requests a signature bond with conditions that the defendant have no contact with Regina P. That he be banned from the Motel 6 at the 4200 block of East Town Boulevard, and that he not possess or consume any alcohol.
No objections to any of the conditions. Thank you.
Okay, order signature bond. Condition will be a no contact director indirect with Regina P. A ban from the Motel 6 at the 4200 block of East Town Boulevard. That she not possess or consume any alcohol, and will be adjourned. You're welcome.
Next up is Marcel Phillips. Philip.
We'll call the state of Wisconsin versus Markel Phillips. It's 26 CM 494 appearances.
John Bake for the state.
Mr. Marquel Phillips appears in person and in custody alongside Attorney C. Joseph Ventola. We have received a copy of the criminal complaint. We would waive its formal reading. I can confirm that the address on it is correct. And it would appear that Mr. Phillips is eligible for public defender services. Thank you.
Great, I'll make findings of probable cause and are not guilty pleas to the charges. And state's position on bail.
State's requesting a signature bond with conditions that the defendant have no contact with Raphael A.P. and that he be banned from the Bristled Boar Bar in Middleton.
No objections. Thank you.
Right, we'll order a signature bond. Condition will be a no contact direct or indirect with Raphael A.P. and a ban from, did you say the Bristled Boar Bar?
Bristled Boar Bar, yes.
In Middleton, and we'll be adjourned.
Freddie Swing. Next up is Freddie Sparks-WARD.
Right, we'll go on the record in the state of Wisconsin versus Freddie Sparks-WARD. That's 26 CF 511 appearances.
John Bake for the state.
After this, no, I'm not gonna say it.
Yeah, 5 million, I guess I'll get out. So weird. Yeah.
Oh, that just. Throw back again. It's still the no docs, that's not.
I thought I'm logged out.
Here on red. Because it's still. But I have it here sent here right now.
Oh,
Yeah.
I am.
Well, send it again.
Yeah. All right.
Oh, all right. All right, thank you for your patience. Mr. Freddie Sparks-WARD appears in person and in custody alongside Attorney C. Joseph Ventola. We have received a copy of the criminal complaint. We can confirm that the mailing address on it is correct. We would waive its formal reading. I believe that these are all felony charges.
Correct.
Yes. And I'm not able to verify his eligibility for public defender services at this time, but it does appear he has a sentencing after revocation where he is represented by a public defender.
Okay, so you're probably going to be eligible, but you got to give them a call on this new case. They've given you the contact info. I'll make findings of probable cause, state's position on bail.
State's requesting $2,500 cash bail with conditions that the defendant not consume or possess any controlled substances or drug paraphernalia without a valid prescription, and that he not use or possess any firearms. Your Honor, here, the defendant does have a long criminal history, which does include drug dealing. As mentioned or alluded to just moments ago, he is, or supposedly was on probation. It's my understanding that he was revoked. Nevertheless, he allegedly here sold fentanyl, as well as was found in possession with handguns. Some cash is necessary to ensure his appearance.
Attorney Ventola.
I understand that given the number of charges and that they are all felony charges, that the court is going to be treating this as a cash bail case. I would be asking for a lower amount of cash bail, maybe about $1,000. While these are certainly not light and breezy charges, they are not Act 3 eligible. At least I don't believe so.
They are not.
They are not, yes. So these charges are not Act 3 eligible, which means that the court is considering an amount of cash that would ensure Mr. Sparks-Ward's appearance in court. What I find noteworthy in support of this is that I reviewed his record on CCAP, and I found he's actually, at least in the last 2 years, quite good about coming to court. He's had multiple felony cases in that time, 25 CF 662, 24 CF 1321, 24 CF 2927, and 24 CF 854. There was a note in the last case of a non-appearance, but he had actually just come to court late and ultimately no warrant was actually issued. He did go to court that day. That is to say that in the last 2 years, despite the number of cases and the severity of some of these cases, Mr. Sparks-Ward has made his appearances, which is the primary consideration for the court today, is an amount of cash to ensure his appearance. I believe that his record shows that he will come to court. I would also note that my understanding is he was not convicted on those previous cases. Those cases were dismissed. And so even though he did collect a few felony cases over the last few years, he was not actually convicted of any of them. His last criminal conviction is actually 2016. So it has been a decade with Mr. Sparks not being convicted of any crimes. I would ask the court to consider a lower amount of cash bail. I think $1,000 would be appropriate given the circumstances here. Thank you.
All right. Well, the charges are very strong. They're UC buys, and then they find all sorts of drugs and guns. It's not minute amounts of drugs that he's alleged to be involved with. And we're not talking about THC, we're talking about fentanyl and other more serious drugs along with the weapons. You probably don't want to say anything on the record here. Well, you don't have to apologize, but I just don't want you to say anything that's going to get used against you later on until you have a chance to talk to your lawyer. Because we're recording all of this, it all can be used against you later on. And I'm not determining that you're guilty or not, Mr. Ward. It doesn't look great, but all I have is the information in front of me here today, and I certainly understand you have your side of the story and you want to tell your lawyer that first before you're telling anybody else, though. I think the request for $2,500 cash bail is warranted. This is a decent prison case if convicted, given the history being on supervision, firearms, and the amount and weights of the drugs. It's a strong case. And given the guns and all the drugs, that's consistent with somebody who's got some access to significant cash. So I think something higher than what you requested, Attorney Ventola, is appropriate. I'll adopt the state's request. I'll order that you not use or possess controlled substances or drug paraphernalia without a valid prescription. And I'll make it a little broader condition. I'll order that you not use or possess dangerous weapons. That includes firearms. And then what about time limits for the preliminary hearing?
Hearing is time limit. It's 20 minutes. If you want to wait, don't.
Look, I can move it, because I'm still gonna be in jail.
This is the revocation.
Yeah.
Okay. Mr. Sparks-Ward has expressed that he would like to waive the time limits.
Okay, that's fine. We'll be adjourned.
Good luck.
Next up is Eric Scott.
Did he wait time? Sorry, I spaced out for a sec.
There's so much stuff happening right here. If you want to keep that.
All right, we'll go on the record. The state of Wisconsin versus Eric Scott. It's 26 CF 510 appearance.
John Vick for the state.
Mr. Eric Scott appears in person and in custody alongside Attorney C. Joseph Ventola. We have received a copy of the criminal complaint. We would waive its formal reading. I can confirm that the address on it is correct. It would appear that he is eligible for public defender services. I should also mention that we are standing mute as to the misdemeanor charges. And at this point in time, I would be moving to dismiss count one, just based on what is within the four corners of the complaint. If the court would like argument on that now, I can do that.
Sure.
Okay. Well, Mr. Scott is charged with operating a motor vehicle while under the influence. What the state must, at this stage, establish probable cause for is that he had consumed an intoxicant to the point that his operation of a motor vehicle was impaired. What we have in the complaint is initially a traffic stop for speeding. What I'm sure the state is aware of is that police officers are trained, and it is generally accepted that speeding is not an indicator of impaired driving. That is, even according to the National Highway Traffic Safety Administration, speeding is not an indicator of impaired driving. Officers claim that they observed slight jerky movements in the car. That language to me is very vague, and one thing that struck me, having reviewed quite a few OWI complaints, is that if he were swerving, if he were deviating from his lane, if there were near misses or almost hitting the curb, the complaint would say that and the officers would say that. What we have here is this vague claim of slight jerky movements. Again, no indication that there are even lane deviations or anything that would be an indicator of impaired driving. Then Mr. Scott declines to do standardized field sobriety tests. There is no PBT taken. Ultimately, there's a blood draw, but there is no indication of what his blood alcohol concentration is. While there was some evidence that he had consumed some alcohol, and he did say to police, or at least is alleged to have said to police that he consumed some alcohol, the fact of the matter is it is legal in the state of Wisconsin, and in fact in every state, to consume some amount of alcohol and then drive a motor vehicle. What the state has to establish probable cause for is that he had consumed enough of an intoxicating substance to the point that his driving was impaired. Those facts are simply not here. So I would ask the court to dismiss count one based on what has been alleged. Thank you.
Okay, and any response from the state?
Yes, Your Honor. Well, the jury instruction for OWI says that what must be established is that the person consumed a sufficient amount of alcohol to cause the person to be less able to exercise the clear judgment and steady hand necessary to handle and control a motor vehicle. Here it's true that essentially the bad driving was those slight jerky movements as well as the speeding. However, there is probable cause for an OWI here, given that the officers noted a distinct odor of intoxicating beverage, that it also came from his person, that he had glossy, bloodshot eyes. He apparently made statements that he took some shots while he was at the job. Also said that his mother had just passed away, and therefore he didn't care that he got another OWI. I think the law would be really bad if there had to be bad driving in order to establish an OWI. That's why we have field sobriety tests, and his refusal also gives PC for an OWI. I think there's sufficient PC here.
All right, let me take a closer look at things.
I would also just briefly note, if the court will allow it, while the law does not require evidence of bad driving, the law certainly does require some evidence of impairment, whether that's because of a prohibited alcohol concentration or other behavior. I would also note that there's not even any indication when Mr. Scott stepped out of the car that he was unsteady on his feet, that he had problems balancing, that he was slurring his speech. There's just a couple of vague conclusory remarks and a statement that he smelled of alcohol, and that he mentioned that he had had some alcohol. But again, it is lawful in the state of Wisconsin, as it is in every state in this country, to drink some amount of alcohol and then drive a motor vehicle. What the state needs to establish probable cause for is that there is impairment, that his driving was impaired because of his intoxication. Those facts are not alleged in this complaint.
All right. Well, I do think it is important to note that he was speeding, he's violating traffic laws allegedly. While you say that's not an indicator of impairment, to me, that suggests somebody who's not necessarily exercising great judgment. Sure, you can be sober when you're speeding as well, but that's just one of the factors that I'm taking into account. He had the other indicators of alcohol consumption, not only the admission, but then there was an open alcohol container in the vehicle with other containers that were unopened, the admission of drinking, the odor of alcohol, glossy bloodshot eyes, demeanor that was lethargic. I don't think that all gets you to there for probable cause for impairment. But then he refuses, and there's the consciousness of guilt factor when you refuse to take those tests. I think that pushes them over the margins for today's purposes. Certainly, trial's a different issue. I have never understood why the state doesn't charge the PAC violation when somebody's subject to an O2. They seem to think they don't have a test score, they don't have probable cause for that. They have clear probable cause for PAC, even though they didn't charge it here. The case law is pretty clear that, odor of alcohol is sufficient to get you to probable cause for asking for a PBT. They've got beyond that. So I'm not sure why they charged it the way they did at this particular point in time. But I think there still is probable cause for count one. But it's a close call, and I understand the reason the motion was brought. But I'll deny it. I'll find probable cause for the other charges. What's the state's position on bail?
State's requesting $1,000 cash bail with conditions that the defendant not operate a motor vehicle and that he not consume or possess any alcohol. He does have an open case for a domestic battery related offense. This is a fifth offense OWI. If convicted, he does face mandatory prison. Given the amount of exposure, we would be asking for significant cash.
Right, Attorney Ventola.
I would just ask for one moment. I wanted to check one thing in Mr. Scott's record. Okay, I was just checking if there were any out of custody appearances yet on the 26 CM 405 case. There have not yet been. It is my understanding that he was out on a signature bond. I would, however, note it appears that his most recent case before that was 23 CT 296. That was the third OWI offense. Oh, well, there should be one after that, shouldn't there? There it is.
Yeah, there's 23 CF 1242. That was
Yes.
the OWI fourth.
Or yes, 1242, yes. On both of those cases, I do not see that there were any appearance issues for Mr. Scott. Sorry, I should be clear. We are asking for a signature bond on this case. Mr. Scott, on his other open case, is represented by a public defender. He is indigent. He has lived in Wisconsin for the last 20 years. He has been relatively recently employed working in landscaping. I do believe he has significant ties to the community, and importantly, these are not Act 3 eligible offenses. I know that there's going to be some concern given that there is a felony charge here with a presumptive minimum of prison time. But I do believe that Mr. Scott has generally shown that he will come to court, which is the primary consideration before this court today. Thank you.
All right, and any response from the state?
No, Your Honor.
Well, I'm looking at that 26 CM 405 case that he's out on that had recommended cash bail. I think that had more to do with the nature of the charge. He was kind of in the middle of the road. 4 out of 6 on new criminal activity, 3 out of 6 on failure to appear. It did indicate prior failures to appear older than 2 years, prior sentences to incarceration, and quite a violent history, 3 or more prior violent convictions. I guess the kind of where I come down on some of these mandatory minimums that are relatively small, we're not talking about 20 years in prison or 25 years in prison, is that in and of itself is close, but it doesn't get you there. We got more than that. We've got somebody who has missed at least once in the past, has an extensive history and was out on bail. So I think there is a need for cash bail here now that he's looking at mandatory prison time. I guess when I come to that conclusion, I think the $1,000 is appropriate given the stakes here. I'll set that. I'll order that you not operate a motor vehicle at all, that you not possess or consume any alcohol at all. What about time limits for the preliminary hearing?
We will be keeping the time limits. Thank you.
Okay, we are adjourned. Good luck.
All right, so right this way. Next up is Naomi Castro.
It just makes sense, sure.
That's true.
We'll call the state of Wisconsin versus Naomi Castro. It's 26 CM 500 appearances.
John Bake for the state.
Can I ask you one question? Is that video on? No, okay, what's the? This one,
Yes.
okay, all right, we'll inform the court in just a moment. Ms. Naomi Castro appears in person and in custody alongside attorney C. Joseph Ventola. We have received a copy of the criminal complaint. We would waive its formal reading. The mailing address on it is not correct. A better mailing address is 1186 Moreland Road, Madison, Wisconsin, 53713. And I believe, yes, we would stand mute as to the misdemeanor charges that Ms. Castro is facing. Oh, and she is not eligible for public defender services. Thank you.
Okay, so Ms. Castro, Attorney Ventola is going to help you today. The deputy's giving you the public defender information. You can always reapply with them. But if you're able to hire an attorney on your own, you certainly can do that as well. The middle option is applying for a county attorney if you're not eligible for a lawyer through the public defender and can't hire an attorney on your own. I'll make findings of probable cause and are not guilty pleas on Ms. Castro's behalf. State's position on bail.
State's requesting a signature bond with conditions that the defendant have no contact with her three co-defendants in this case, that she have no contact with Officer Joy, except in his official capacity as a law enforcement officer, and that she be banned from the Soto nightclub on North Henry Street in Madison.
All right, Attorney Ventola, I don't intend to order the ban on the contact with the co-defendants because I didn't do that with the other co-defendant. But if there's any objection to the other condition about the Soto nightclub and having contact with the officer, I'd be interested in hearing that.
Would be banned.
Oh, no, I'm.
Okay. We're not going to be objecting to the conditions, save for the ban on speaking to co-defendants. It's actually my understanding Ms. Castro only personally knows co-defendant Rodriguez, and so we don't necessarily have a problem with no contact with co-defendants Hueso Portillo and Perez Lorenzo, but co-defendant Rodriguez, she would like to have contact with.
Okay. I'm just not gonna order it to be consistent with the other defendant. I'm not satisfied that it's necessary to protect the public. I haven't heard about a history of them picking up crimes together or any prior record at all. So I'll order a signature bond. You're gonna be banned from the Soto nightclub. You can't have any contact with Officer Joy except as that's necessary during the officer's duties as a law enforcement officer, and will be adjourned.
All right. We'll give you a notice for your next court date, okay?
Right this way.
All right. Good luck to you all.
This way. Next up is KRYSTAL Belmonte.
We'll call the state of Wisconsin versus KRYSTAL Belmonte. It's 26 CF 508 appearances.
John Bake for the state.
Yeah.
Okay. Ms. KRYSTAL Belmonte appears in person and in custody alongside attorney C. Joseph Ventola. We have received a copy of the criminal complaint. We would waive its formal reading, stand mute as to the misdemeanor count. I also can confirm that the mailing address on it is correct, and it would appear that she is eligible for public defender services. She appears to currently have a public defender through our office on her other open case.
All right, I'll make a finding of probable cause and or not guilty plea to the misdemeanor. State's position on bail.
State's requesting $500 cash bail with the condition that the defendant not use or possess any controlled substances or drug paraphernalia without a valid prescription. The defendant has several, I believe, just over half a dozen cases, open cases across Juneau and Dane counties. Here, it's alleged that she was resistive with officers as they attempted to take her into protective custody. I think her behavior here, as well as the amount of open cases at this point, give the state concern that she will not appear in any future court appearances, and therefore we ask for cash.
Right, and Attorney Ventola?
So we're not going to object to the non-monetary conditions that the state has proposed, but we would be asking for a lower amount of cash bail, maybe in the realm of $250. What I would note about this case and about Ms. Belmonte, just from reading this complaint, it seems pretty clear that there's some kind of mental health crisis and possible addiction issues going on. That doesn't mean that the behavior is the behavior that's alleged is acceptable or that it should be tolerated, but it's definitely something for the court to consider that this is someone who is in crisis. And when these events were happening, Ms. Belmonte was in crisis. She is indigent. She has been deemed eligible for public defender services. She already has a public defender. A $500 cash bail is a quite significant amount of money for an indigent person to post. I think given the mental health issues that this case suggests could be present, I'm just concerned that a custodial environment would be particularly detrimental to Ms. Belmonte. Although given that there are multiple open cases and that one of them is a felony, I think some amount of cash is appropriate. So we would ask for a lower amount in the realm of $250. Thank you.
All right. So I'm not sure she has a half dozen cases. I think she's got 4 cases that are pending before this one. It looks like she's had to post cash bail on several of those cases, $700, and one of the out of county cases that was 25 CF 263. Looks like $700 was posted on December 16th of last year, and then I think she got some signature bonds and some other cases. Also, looks like she had posted $400 on December 9th of 2025 in Juneau County case 25 CM 408. So it's concerning that she's piling up so many cases. She's done so after posting cash bail, and it looks like she's been able to do that relatively quickly in all of the cases. And then we have the resistive obstructive behavior. I don't dispute that there's mental health component to this. It also looks like, in looking at those cases, there's a drug and alcohol issue as well. I see it as a cash bail case. I think the $500 is reasonable. I'll set that. I'll order that you not use or possess any controlled substances or drug paraphernalia without a valid prescription. You will have the right to have a preliminary hearing in the next 20 days. Should we get that scheduled?
Do you want to keep that time? It's 20 days. We will be keeping the time limit. Thank you.
Okay, we are adjourned.
Right, next up is Charles Hannon.
You're welcome. Great, we'll go on the record in the state of Wisconsin versus Charles Hannon. It's 26 CF 197 appearance.
John Bake from the state.
Yeah, okay. Mr. Charles Hannon appears in person and in custody alongside Attorney C. Joseph Ventola. We have received a copy of the criminal complaint. We would waive its formal reading. I can confirm that the mailing address on it is correct. Stand mute as to the misdemeanor counts. And it would appear that Mr. Hannon is eligible for public defender services.
All right, so it looks like he's got a body only hold out of Milwaukee County in case 24 CF 3368. I'll make findings of probable cause in this particular case. And are not guilty pleas to the misdemeanors. What's the state's position on bail?
State's requesting $5,000 cash bail with conditions that the defendant have no contact with Tiana L, TIANA, and that he be banned from the 3900 block of Lean or Len Road, Lein. Your Honor, as you just mentioned, he is still on warrant status for a Milwaukee case that he failed to appear in September of last year. The alleged incidents in this case happened just less than 1 month after serving a sentence for escape here in Dane. Or I'm sorry, I think that was for, I believe that, so I think the out of warrant status occurred just less than 1 month after serving the escape sentence here in Dane. He does have significant criminal history out of Illinois as well between 2005 and 2022. So it seems he has ties in Illinois, which increases his failure to appear risk. Therefore, we'd be asking for significant cash bail.
Attorney Ventola.
I understand that the court is going to be treating this as a cash bail case, given that there are felony allegations and given the warrant out of Milwaukee. I think the first and easiest point I would make is that we are objecting to the no contact condition. I don't have a whole lot of information to offer in support of that, except that TVL waived the 72-hour no contact, which unless the state has more information, suggests to me that she likely does want contact with Mr. Hannon. Again, I welcome the state to correct me. I would also note that Mr. Hannon and TVL have two children, or sorry, one child together, age 1, and he has another child, age 16. Both of these children, reside with him. Oh, and she's currently pregnant with another child that is Mr. Hannon's. Apparently she is due any day now. So I think just on those grounds, a no contact would not necessarily be appropriate here. If there's no other indication on TVL's desires, I think her decision to waive the 72-hour no contact suggests that she does want contact with Mr. Hannon. As for cash bail, I would ask the court to consider a lower amount. I know that it's going to be treated as a cash bail case. I would just say in support of that, first and foremost, there is a holdout in Milwaukee County, so that is something that he will have to address before he is totally released from custody. So there could be additional cash bail that he faces there. He is indigent. He has been deemed eligible for public defender services. So any amount of cash bail is going to be quite difficult for him to post. And again, he has lived in Wisconsin for the last few years, and he does have 2 children living with him, one of whom is 1 year old. And again, he's expecting another child any day now. So I would ask the court to consider a lower amount of cash bail, but I understand that this is a cash bail case. Thank you.
Yeah, I think given the failure to appear, he's been out on that warrant for several months. The prior history is not great. These are Act 3 eligible offenses, at least counts 1 and 3 are Act 3 eligible offenses. I think it's a cash bail case. I can see a cash bail lesser than what the state's requested that is sufficient for the goals that the court has to assure appearance in court and protect the public. I'll set cash bail at $2,500. I guess where I'm a little concerned in regards to the contact, I noticed that the 72-hour no contact was waived. I also know it was a violent incident that resulted in injuries. And there's the charge of intimidation. I don't believe we had the victim present to hear from them. Not that I am perfect at that, but I do kind of like to hear from them. Sometimes you can judge from the way they're speaking, the demeanor, as to whether maybe this person doesn't really want the thing that they're asking for because they're afraid about domestic violence and the repercussions with that. So I'm gonna order it, no contact with Tiana L. I'll allow contact through a third party though, for purposes of having contact with any of their children in common, and order the ban from the 3900 block of Lean Road. Right now, all of this is probably moot, given the Milwaukee County hold. He's gonna have to sort that out and get bail there before he could even be released. Given all that, should we just get it set for a prelim in the next 10 days to get things moving forward?
Only through a third.
Sorry, I was answering a question from Mr. Haney.
Yeah, I was just asking, given
time
all the
limits?
stuff he's got going on, does he want to prelim in the next 10 days? Just to get it moving forward?
Yeah, I got a question. Why the contact? Like, I have no family, nobody but her, and I can contact her because she's due with my son any day now. There's no problem between me and her. This happened way back.
Okay, and I don't want you to talk about the facts of the case because we're recording this and you've got the right to remain silent. Anything you say can be used against you later on. What I would suggest is you have your attorney file a motion to review the bail notes if you're not able to work on contact through a third party. Right now, you're gonna be able to have contact with your kids, or it's gonna be exceedingly difficult. Because I don't even know where you're gonna be. You're gonna be in custody here and then potentially taken to Milwaukee in custody. So I've entered my order. So yeah, I'm not allowing that at this particular point in time, given the intimidation charge. All right, we are adjourned.
All right, right this way. Next up is Anthony Cullen.
Right, we'll call the state of Wisconsin versus the Anthony Collin. It's 26 CM 497 appearances.
John Bake for the state.
Mr. Anthony Collin appears in person and in custody alongside Attorney C. Joseph Antola. One moment, please. Mr. Collin, second. Yeah, okay. We have received a copy of the criminal complaint. We would waive its formal reading. I can confirm that the mailing address on it is correct. And it would appear that Mr. Collin is not eligible for public defender services at this time. Oh, and stand mute as to the misdemeanor charges. Thank you.
All right, so Mr. Collin, the deputy is giving you the public defender info. You can always reapply. You could hire an attorney on your own. If you're not able to, you can apply for a county attorney. That's the middle option. And
Questions?
I think Attorney Ventola wants to make sure you're not saying anything that's on the record and taken down. It's all being recorded, can be used against you. That's why he's suggesting you just quietly talk to him about questions. I'll make findings of probable cause and are not guilty, please. State's position on bail.
State requests a signature bond with conditions that the defendant that the defendant not direct any acts or threats of violence towards Jorge C. as well as Austin C. and that he not use or possess any dangerous weapons as that term is defined by statute.
Any objections?
No objections. Thank you.
Okay, so order a signature bond. Conditions will be that you direct no acts or threats of violence towards Austin C. and Jorge C. and that you not use or possess dangerous weapons as that's defined by the state statutes. And we'll be adjourned.
Right this way. Next up is Larry Lanier.
It might be the last one.
I'm asking for cash.
Great, we'll go on the record in the state of Wisconsin versus Larry Lanier. It's 26 CF 518 appearances.
John Bake for the state.
Mr. Larry Lanier appears in person and in custody alongside Attorney C. Joseph Ventola. We have received a copy of the criminal complaint. We would waive its formal reading. I can confirm that the address on it is correct. We would stand mute as to the misdemeanor counts. And it would appear that Mr. Lanier is eligible for public defender services. Thank you.
Great, I'll make findings of probable cause and are not guilty pleas to the misdemeanors. State's position on bail.
State's requesting $8,000 cash bail with conditions that the defendant not operate a motor vehicle, that he not possess or consume any alcohol, and that he not possess or consume any controlled substances or drug paraphernalia without a valid prescription. Here it's alleged that after the traffic stop, the defendant refused to identify himself to law enforcement. He was given a notepad to write his information, but instead opted to just scribble on the notepad. He then takes off from the traffic stop, which is when the pursuit begins. He crashes during the pursuit. Thankfully, no one was hurt during this incident. But I think all of this demonstrates that the defendant's not someone who would be willing to come to court absent some cash on the line. Therefore, we would be asking for significant cash bail.
Right, and Attorney Ventola.
If I may just have one more minute to speak to Mr. Lanier.
Sure.
Your Honor, in addition, if the defendant posts cash bail or if no cash bail is ordered, we would ask pretrial services be employed to ensure sobriety.
All right, thank you for indulging me for a moment. I've spoken to Mr. Lanier. We're not going to be objecting to any of the non-monetary conditions that the state has proposed. We are going to ask for a lesser amount of cash bail. I would note a few things in support of that. First and foremost, I understand that this is a cash bail case, given what has been alleged. And I've explained to Mr. Lanier that this is a case where he's going to be looking at cash bail. But I do think that there are at least some factors that weigh in favor of less than $8,000. Mr. Lanier has significant ties to the community. He has lived in Wisconsin for the last 15 years. He has also been consistently employed between two jobs for at least the last year. I'm aware that he currently works at a Little Caesars. I would also further note that Mr. Lanier has been placed on probation in the past and, to my understanding, successfully completed probation. There are at least some indicators, despite the nature of these allegations, that Mr. Lanier is capable of complying with court orders, capable of coming to court, and would do so on this case. Again, I understand that this is going to be a cash bail case, given what's alleged, but I would ask the court to consider an amount less than $8,000. Mr. Lanier, though hardworking as he appears to be, is still ultimately indigent, and $8,000 is going to be a pretty extreme amount for someone in his circumstances to post. Nothing further. Thank you.
All right, any response from the state?
I suppose I left something out from the notes. I'll just address it briefly. The defendant's also a registered sex offender, and his status in the registry is listed as non-compliant. So I think that further demonstrates that significant cash bail is necessary.
All right, but he obviously wasn't under active supervision.
No. Not to my understanding, anyway.
Mr. Lanier has represented, he believes that the only reason he would be not compliant, he said that he checks in every Monday, and then he thinks the only reason he might be listed as not compliant is because he was not able to check in this Monday because he's in custody. I don't know if there's been any other problem, but he's quite insistent that his check-ins are regular every Monday.
Okay. Well, obviously, there isn't any sort of hold for any sort of active supervision that I'm seeing or been made aware of. I didn't see a history of missing court. He did have a third-degree sex assault conviction in a Dane County case. That was a 2018 case, so somewhat dated, but serious. This is clearly cash bail territory. This is obviously not the first time Mr. Lanier's had contact with law enforcement, not the first time he's been pulled over for an OWI, and then he takes off and they're alleging he's going 90, 100 miles an hour. Extremely dangerous for him and anybody else out there. There's a need for significant cash bail. And I guess Mr. Cochran notes that according to the DOC locator website, he's not compliant with the sex offender registry program, but he's not on obviously extended supervision or parole right now. At the end of the day, I don't know that that's a huge factor in my mind. It may be that because he's been in custody, there was a violation that was listed with respect to that. To me, this is just not a case where a signature bond's appropriate given his history. I'll set it at $4,000. I'll order that he report to pretrial services no later than 10 a.m. on the business day following release. If he is able to post the bail, I'm going to order that they equip you with a breathalyzer to make sure that you're not drinking alcohol. The deputy's giving you the map to their office. They're on the 5th floor of the courthouse. And then I'll order that you just not operate a motor vehicle as well as a condition of bail. So what about time limits for the preliminary hearing, Attorney Ventola? Oh, I think I had overlooked that. It's a restatement of the law. So I don't see harm in ordering that. If there was indications of drug use, I'm not sure that I recall that, but let me take a look at the complaint again. Yeah. Attorney Baker, is there an indication as to controlled substances?
We will not be waiving the time limits. Thank you.
I guess there was an odor of marijuana. I guess I'm not gonna order drug testing through pretrial services. I declined to order the condition. Other than you can't drink alcohol, you can't operate a motor vehicle at all, and then the cash bail and pretrial services. Right, we are adjourned.
That's everyone.
All right.